Let's bring in George Washington University Law School professor Johnathon Turley. Johnathon, I heard some reaction from you. It is quite something to see this moment, and it's really historic, this moment that we're facing.
It is. It's historic. It's not necessarily good history that is being made. It's not that I oppose the indictment of a former president. I don't even oppose the indictment of a sitting president on constitutional basis. But this indictment, if it is reportedly following the theory that we've been talking about, is political. It's a raw political prosecution. Now, the indictment may come out with a crime that none of us have heard of, but for many months, this bootstrapping theory has been put out there. This idea that you could take a misdemeanor under New York law that has expired, that has a 2-year statute of limitations, and revive it by connecting it to a federal crime, in this case, the federal election violation. Now, there's a host of problems with that. First of all, it's a federal crime the Department of Justice chose not to prosecute. Bragg's own predecessor declined to prosecute. But he is attempting to bootstrap that federal crime into a state case. And if that is the basis for the indictment, I think it's rather outrageous. I think it's legally pathetic.
Looking live at Mar-a-Lago, Palm Beach residence for the former president. I want to read just a paragraph from the New York Times documenting of this in this story. It says, on Thursday, the 3 lead prosecutors on the Trump investigation walked into the building where the grand jury was sitting in the minutes before the panel was scheduled to meet at 2 p.m. One of them carried a copy of the penal law with Post-it notes visible, which was likely used to read the criminal statutes to the grand jurors before they voted. About 3 hours later, the prosecutors walked into the court clerk's office through a back door to begin the process of filing the indictment. As you rightly point out, Johnathon, the federal prosecutors in the Southern District of New York chose not to go down this road with this case. The Federal Election Commission chose not to go down this road with this case. And then Alvin Bragg himself, as district attorney, when he first took office, did not put a hold indefinitely on going down this road, but then revived it and talked publicly about that.
Yeah, and part of the problem, Brett, is that you had Bragg throw a flag on this case, which was the right thing to do. And then his 2 lead prosecutors resigned in protest. And one of them took the, in my view, outrageous step of writing a book about the investigation, which was still ongoing. The subject of his book was an individual who hadn't been convicted or charged. And so this book really ramped up the pressure on Bragg. But the other interesting thing about this is that there's a good reason why the Department of Justice did not prosecute this case, because it's been down this road before. It tried a case against former Democratic presidential candidate John Edwards, arguing that hush money paid to another woman who bore a child out of that relationship was in fact a campaign violation. That was a much stronger case, but they lost. And the reason they lost is because even if you can bootstrap that dead misdemeanor into something alive, you're essentially arguing a federal case that the Department of Justice declined. But it's also a case that requires you to show, if that is the basis of this indictment, that Trump's his sole motive for paying this money or having third parties pay it was for the election. Well, that's the problem from Edwards. There's a host of reasons why a celebrity and a married individual would want to hush up an affair, particularly with a porn star. Yeah,
I want to talk a lot about the process here and the negotiation that's going to happen, how the handover, the dealing with the Secret Service, the fingerprinting, the photograph. We've been through kind of speculation about this. But one last thing on the legal case. You talked about how this is new as far as its construct. And judges would have to evaluate that not only first on the case itself, but then if you got to a conviction, on an appeal that could last for a very long time. Meantime, there are other federal cases that perhaps are stronger if you are really going after the former president. The federal case in Georgia about election interference, and not to mention the special counsel and the January 6th investigation.
Yeah, and look, Bragg is clearly counting on a motivated judge and a motivated jury. You couldn't pick a better jurisdiction. But if he's using the bootstrap theory, which is the only one that's been discussed publicly, that is unprecedented. And I expect that New York judges will have the same reaction of many of us, including people on the left, that this doesn't read right. This is not, under Bragg's theory, he can take any unproven federal crime and revive a long dead misdemeanor and turn it into a felony. That's going to really, raise concerns for a number of judges. But once it gets to the appellate level, he's going to have a particularly difficult time, in my view.
Johnathon, thank you.